Chapter 25. Preferences, Equity Delights in Equality. SS 390. Preferences legal. In the absence of a bankrupt act, the principle prevails in most of the states that an insolvent debtor may make preferences among his creditors, even to the extent of transferring all his property to one creditor to the exclusion of the others. The common law favors and rewards the vigilant and active creditor. The right of a debtor under the rules of the common law to devote his whole estate to the satisfaction of the claims of particular creditors results, as Chief Justice Marshall declares, from that absolute ownership which every man claims over that which is his own. If, while a man retains his property in his own hands, the right of giving preferences should be denied, he would so far lose the dominion over his own that he could not pay anybody, because whoever he paid would receive a preference. It makes no difference that the creditor and debtor both knew that the effect of the application of the insolvent's estate to the satisfaction of the particular claim would be to deprive other creditors of the power to reach the debtor's property by legal process or enforce satisfaction of their claims, if there is no secret trust agreed upon or understood between the debtor and creditor in favor of the former. But the sole object of a transfer of property is to pay or secure the payment of a debt. The transaction is a valid one at common law. The distinction is between a transfer of property made solely by way of preference of one creditor over others, which is legal, and a similar transfer made with a design to secure some benefit or advantage from it to the debtor. It is an absurdity to say that a conveyance of property which pays one creditor a just debt and nothing more is fraudulent as against other creditors of the common debtor. In a fair race for preference, if a creditor by diligence secures an advantage, it may be maintained. But if his purpose is not to collect the claim, but to help the debtor cover up his property, he cannot shield himself by showing that his debt was bona fide. We may here observe that an insolvent debtor may prefer his daughters to the extent that they are his creditors as his wards, although such preference may leave the debtor without the means of paying his other debts. In a controversy recently before the Supreme Court of the United States, construing the statute of Illinois, it was decided that a preferential disposition of all the assets of an insolvent debtor operated as a general assignment. The decree appealed from entirely excluded the preferred creditors from participating in the fund. In modifying this decree, Mr. Justice Harlan said, "The mother, sisters, and brother of Alexander White, Jr., were his creditors, and, so far as the record discloses, they only sought to obtain a preference over other creditors. But their attempt to obtain such a legal preference ought not to have the effect of depriving them of their interest under the statute in the proceeds of the property in question, or justify a decree giving a prior right to the appellee. It was not intended, by the statute, to give priority of right to the creditors who are not preferred. All that the appellee can claim is to participate in such proceeds upon terms of equality with other creditors. SS 391 must represent actual debt. The preferred creditor must have a valid subsisting claim against the debtor which the transfer was given to satisfy or secure. In Union National Bank v. Warner, the conveyance was made by a father to his sons, who were, however, not creditors, the mutual fraudulent intent being shown. The conveyance was annulled, their agreement to pay some of his debts being deemed a part of the fraudulent scheme which fell with it. So in Davis v. Leopold, the conveyance by a husband through a third person to his wife was set aside, the wife not being a creditor, while in Crown and Shield v. Kittredge a mortgage was annulled because it was given for a fictitious or excessive amount, and executed for the double purpose of securing a bona fide debt and preventing creditors from attaching the property. SS 392. Vigilant creditors. The general rule in equity only requires that the fund acquired by a creditor's proceeding should be distributed among the creditors pro rata, and where a creditor has not obtained any lien at law, not having obtained any judgment, he is not entitled to a priority over the other creditors. The commencement of a creditor's suit in chancery by a judgment creditor, with execution returned unsatisfied, gives him a lien upon all the equitable assets of the debtor, and the same general rule is applied to supplementary proceedings. The first party to move is rewarded as a vigilant creditor, the commencement of his suit being regarded as an actual levy upon the equitable assets of his debtor, and entitles him to a priority. A purchaser pendent light with notice will take subject to the rights of the complainant. The vigilant creditor, pursuing his claim, acquires a preferable equity, which attaches and becomes a specific lien by the filing of his bill. This right is said to be as well defined and as exclusive of the claims of other creditors as is the right secured by a judgment lien upon the debtor's property, where a party purchased lands pending a suit to reach the judgment debtor's interest therein. and entered into possession and made improvements, such a grantee is not entitled to have his improvements discharged from the lien of the decree rendered against the land. Equity will not relieve a party from a risk which he voluntarily assumes. This is a phase of the general rule that no allowance will be made for improvements placed upon land after suit brought. The Court of Chancery does not, however, give any specific lien to a creditor at large against his debtor further than he has acquired at law. It is only when he has obtained a judgment and execution in seeking to subject the property of his debtor in the hands of third persons, or to reach property not accessible to an execution, that a legal preference is acquired which a court of chancery will enforce. In New York, the law gives no preference to a vigilant creditor in the estate of a decedent. SS 392A. Preferences in New York for wages. By statute in New York it is provided that in all assignments made pursuant to the Act, the wages or salaries of employees shall be preferred before any other debt. The Court of Appeals held that an assignment was not rendered void by reason of the omission to insert therein a clause giving such preference, as the instrument would be read in connection with the statute with the same effect as though the provision formed a part of it. SS 393. Compromises secret preferential agreements. The law has ever scrupulously guarded the integrity and good faith required in the general compromises of creditors with their debtors, from considerations of public policy and sound morals. Transactions of this character should be conducted with truth and fairness, lest any undue secret advantage be secured to one creditor at the expense of another. Attempts to thwart the application of these salutary principles are common and when detected will be overthrown. In Cockshott v. Bennett, the defendants being indebted to plaintiffs and other creditors in the pound as to all the creditors except plaintiffs, who refused to sign the deed unless the defendants gave them a note for the remaining in the pound. The note was accordingly given, and defendants made a subsequent promise to pay it. Lord Kenyon, in defeating a recovery, placed his opinion upon the foundation that the note was a fraud upon the creditors who were parties to the deed by which their debts were to be cancelled in consideration of receiving in the pound, and observed that all the creditors being assembled for the purpose of arranging the defendants' affairs, they all undertook and mutually contracted with each other that the defendants should be discharged from their debts after the execution of the deed. Upon the point, as to the revival of the debt by a subsequent promise, the learned Chief Justice said, "Contracts not founded on immoral considerations may be revived, but this transaction is bottomed in fraud, which is a species of immorality, and not being available as such, cannot be revived by a subsequent promise." Mr. Justice Ashurst remarked in the same case that the creditors were induced to enter into the agreement on principles of humanity in order to discharge the defendants from their encumbrances, and if they had not thought that such would have been the effect, they would not probably have agreed to sign the deed, but each would have endeavored to obtain payment of his whole debt. Therefore I think that this security is not merely voidable, but absolutely void. The note was void on the ground of fraud, and any subsequent promise must be nudum pactum. So in Jackson v. Lomas, a secret agreement was made by a debtor with a creditor to pay an additional sum, the consideration of which agreement was that the creditor should sign a composition deed with the other creditors. Mr. Justice Buller declared the secret agreement absolutely void, and refused to enforce it. The principle of these English cases is upheld in the early case of Payne v. Eden, in New York, where a note given in consideration of the creditors signing the insolvent's petition to make up the statutory proportion was adjudged void, and in Wigan v. Bush, a note executed by a debtor to his creditor to induce him to withdraw his opposition to the debtor's discharge under an insolvent law was adjudged void. So a note given by a third person to a creditor in consideration of his withdrawing all opposition to the discharge of his debtor as a bankrupt, even though without the knowledge of the debtor, is void. In case v. Jerish, Chief Justice Shaw, in deciding upon an agreement of this character where a note had been given, said, "This was an unwarrantable coercion upon the debtor, and a fraud upon the other creditors, which renders the note void." SS 394. Secret antecedent agreement to prefer. An agreement between a debtor and creditor that, in consideration of receiving a loan, the debtor will prefer such creditor in the event of insolvency, has been considered to be in the nature of a secret lien, which is a fraud upon subsequent creditors of the debtor who are ignorant of the arrangement, and a subsequent disposition of the property in accordance with such an arrangement can be avoided by such subsequent creditors. We doubted the soundness of this conclusion in our first edition, and the case cited has since been overturned and its conclusions departed from. In National Park Bank v. Whitmore, Earl J. said, "A debtor may obtain credit by a promise to pay in the future, either in cash or in property, or by promising to give his check or an endorsed note, or a confession of judgment. Neither such a promise, nor its performance, is a legal fraud upon anyone. And why may he not promise to give security upon the property purchased, or other property such a promise? Honest, in fact, has never been held to be a fraud or to work a fraud upon creditors. Security honestly given in pursuance of such a promise relates back to the date of the promise, and, except as to intervening rights, is just as good and effectual as if given at the date of the promise. And it has generally been so held, even in bankruptcy proceedings. But here the agreement was to make the preferential assignment in case it became necessary to protect the creditor. And it is further claimed that such a conditional agreement is a fraud upon other creditors. A failing debtor may make an assignment preferring one or more creditors because he is under a legal, equitable, or moral obligation to do so. Or he may do it from mere caprice or fancy. And the law will uphold such an assignment honestly made. If he may make such an assignment without any antecedent promise, why may he not make it after and in pursuance of such a promise? How can an act otherwise legal be invalidated because made in pursuance of a valid or invalid agreement honestly made? In Smith v. Kraft, Judge Gresham held that such a conditional agreement for a future preference was a fraud upon creditors. But in the same case, upon a rehearing, Judge Woods held that the same agreement was not fraudulent, and in a very satisfactory opinion showed that such an agreement as we have here, for a future preference in case of insolvency, is not a legal fraud upon creditors. This agreement did not create any lien, legal or equitable, upon the property of the defendants. It was not an agreement for a future lien upon the specific property, which is sometimes held to create an equitable lien which may be enforced in equity. It was not an agreement for any lien at all. It was simply an agreement, in case of an assignment by the defendants, to prefer Whiting. The agreement did not bind defendants' property, nor encumber it, but left it subject to all the remedies of their creditors. And it neither hindered nor delayed those creditors. They could have made the same assignment without a previous agreement, and it is impossible to perceive how the agreement worked any legal harm to anyone. It is not important to determine whether this was an agreement of which a court of equity would enforce specific performance. But we do not believe it was, and think it must stand both in law and equity like an agreement to pay at a future day.